Basis for awards. So we talked about a little bit, we're going to talk about some other issues relative to coming up with the award. On the third day we talked about, I think, or maybe the second day, we talked about reciprocal preference and how depending upon whether another government, another state, Washington, D.C., etc., has some kind of preferences for their resident vendors, that we will apply the same preference against them. So you cannot always just necessarily go on the initial bid prices, etc., for the determination of who's going to win. It's that if there's no other considerations, but then there may be other considerations. First one being reciprocal preference, the second one having to do with responsible vendor. What is a responsible vendor? Well, I'm glad you asked that question because I have an answer. It is a person, and actually person is defined in state law, and a person has about 20 different terms. Person means a firm, business, corporation, association, this, that, it goes on about 20 different things as what is meant by a person. So person does not mean just a single individual. It means virtually anything that can exist. Who has the capability in all respects, and we will take this piecemeal, capability in all respects, so capacity, that's the first key element of responsibility. To perform fully the contract requirements, so they're capable of doing what we want them to do and what supposedly we're going to pay them to do. And the integrity and reliability that shall assure good faith performance. Yeah, they may be capable, but we don't trust them. Well, we don't contract with vendors we don't trust. We don't contract with vendors that we don't believe are capable of doing what we want, and we don't contract with vendors that we can't trust to do what we want. So when you are required, before you make an award, to make an affirmative determination a vendor is capable, responsible. And so what you're doing is saying the vendor has capability, reliability, and integrity. And if you cannot make that determination, you cannot award to that vendor. Something I've probably mentioned in one of the earlier classes was the distinction between responsible and responsive. In terms of responsive is a characteristic of a bid. Responsive only applies to sealed bidding, and it only applies to the bid document, that you can tell that the vendor's price is in response to all the requirements of the solicitation. It is responsive. Conversely, responsible is a characteristic of the bidder or offerer. It is the vendor. So the bid cannot be responsible, and a vendor cannot be responsive. A vendor can only be responsible. Responsibility must be determined regardless of the procurement method. Whether it's sealed bidding, sealed proposals, you must determine a vendor is responsible, or you cannot award to that vendor. Now, sometimes you may do a thorough, involved evaluation to make that determination, and sometimes sometimes is usually what you do, is you do it by an exception. If you don't have a reason not to find them responsible, you find them responsible. The absence of a negative is a positive in that instance. So, but you must find the vendor responsible. And when you're talking about something like, let's say a vendor does not meet minimum qualifications, and we usually establish that for bids and sometimes proposals, what you're saying, in effect, is the vendor is not responsible, because minimum qualification are not a characteristic of their price. It's a characteristic of, do they have the capability to do what the specifications call for? So that's an indirect way of saying the vendor is not responsible, by saying they don't meet minimum qualifications. So you must have this issue for award. Let's see, responsible vendors. State the minimum reasonable qualifications the vendor must have to be considered responsible. And here are some examples of what we mean by that. Minimum experience requirements. You must have at least 3 years of experience doing such and such. Licenses certification. You must be admitted to the bar of the state of Maryland to provide the legal services contracts for both DHMH and DHR, or you must be licensed by the Maryland Board of Nurses to be able to provide nursing services to a facility, to Western Maryland, to Potomac, wherever. You may have requirements such as they have to be located in a specific geographic area. If you have a requirement to provide services in Baltimore City, and you may require that a vendor be located in Baltimore City. That is a minimum requirement. If they're located somewhere else, they do not qualify for an award to serve Baltimore City. So you want to identify these, and you will state something generally to this language, that meeting these minimum qualifications does not mean the vendor is automatically considered to be responsible, but rather that if the vendor does not meet these minimum qualifications, it cannot be considered to be responsible. And I guess what this means is the qualities of necessary and sufficiency. And I don't know whether this comes from philosophy or something like that, but I've at times gone through exercises to determine whether a specific circumstance is a necessary circumstance for someone to be able to do something, and whether it is a sufficient circumstance. So along those lines, what we're saying here is if you meet minimum qualifications, that is a necessary circumstance to continue on the road to maybe receiving the award. But in and of itself, it is not sufficient to automatically mean you are qualified for the award. It just means you've gotten through the first hurdle. You still may not get through the second hurdle, but at least you've gotten through the first. You've gotten your foot in the door, and that's all we can say at this point. So that describes it better than it's described better. If it doesn't, it isn't. All right, basis for award. If it's competitive sealed bidding, you must state if there's any preferences, and we've gone, this is about the third time now we've mentioned some of these. Whether there's a small business preference, whether there's a veterans preference, including disabled veterans, whether there's a locally grown food preference, whether there's a mercury-free or low mercury preference. If it is a small business reserve, obviously you must say that. You must always identify the price that is going to be used to make the award determination. We go over this extensively in the pricing class, but you have to really pinpoint, say the basis for award will be price X on page 4, something like that, so that everyone knows that is the price, that is the one that's being compared.
Question.
Yes?
In the listing before, we had MBE requirements and so forth, and I just saw this veterans. Do we as a state have a veterans requirement on certain contracts above a certain level?
Okay, we have, and I'm not sure, we of course went through the veterans preference in terms of it's a small business that is a veteran-owned small business, and if you give a percentage price preference, you can give an additional 2% if they're a veteran-owned small business, and you can give an additional 1% above that if they're a disabled veteran-owned preference. Do we have, as a state, a veterans preference? Yes and no. And I don't think I've dealt with this before. A law was passed the last session, meaning last spring, that in the future, and I think the future is starting July 1 of 2012, we will have a goal of meeting 0.5% of our procurement awards to veteran-owned businesses. So we have it on the books, it's coming, and it's coming as of a specific date, but it is not here yet. And so it will be similar to MBE in that it will be what's called an aspirational goal. It's something that you will try to achieve, but there's no absolute that if they make a good faith effort, but despite the good faith effort they don't achieve it, that's okay as long as they're making a good faith effort. But you have to determine they're making a good faith effort if they don't achieve it. So it's coming. I don't think it's mentioned anywhere in these things, but it's coming. All right. That's still just one move. I didn't go two. All right, competitive sealed bidding, basis for award. State that the award will be made to the responsible bidder who submits the most favorable responsive bid price. And I don't know why they do this, but if you look up the definition of most favorable bid price, it says lowest price. Why they don't just say lowest price, I don't know. But that's what most favorable bid price means, the lowest price, but it's the lowest responsive price from a responsible bidder. That's your basis for award. So if a vendor is determined not to be responsible, or if its bid is determined not to be responsive, that vendor is not eligible for an award.
There are if we just state the lowest bidder?
What was that again?
Can we use the term since the reward is lowest?
Yes, you certainly may use the term the lowest bidder. That probably would be easier for everybody. Lowest responsive and responsible bidder. All right, competitive sealed proposals, which hopefully I'm not going to say a whole lot on since there's going to be a 3-day class on just competitive sealed proposals. But I will tell you some of the things you must identify. You must identify the evaluation criteria. What aspects are you going to look at to determine if a vendor is qualified, if they are reasonably susceptible of being selected for award, and beyond that, whether they are the most advantageous offer. So you have to say the criteria because you are prohibited from using any criteria that you have not stated in the solicitation that you will use. So you have to say it. You must state the relative importance of each criterion. And all you have to do, let's say there are 5. All you have to do is say whether they are in ascending order of importance, descending order of importance, or of equal importance. I can't remember anyone ever saying the criteria is in ascending order of importance, and I can't remember any time anyone ever said they're of equal importance. So probably the only thing you're going to say is the criteria you have identified are listed in descending order of importance.
So
and if
that
you,
equal statement should be at the beginning of that listing.
the relative importance should be there.
It should say of equal importance.
The proposal submitted in response to this RFP will be evaluated by an evaluation committee appointed for that purpose and will be evaluated on the basis of the following criteria. These criteria will be are listed in order of descending importance, something of that nature. You frequently might have vendors say to you, well, how many points are you giving to criteria 1, criteria 2? I don't know which one is more important. And your answer is, well, 1's more important than 2, and 2's more important than 3. That's what we said, descending order of importance. No, I don't mean that. I mean, what points are you giving to 1 and 2? Like, is 1 worth 30 points and 2 worth 20 points? 1 is the most important. 2 is less important than number 1. That's all I'm going to tell you. That's all I'm required to tell you. That's all I'm going to tell you. Well, don't you have to do it? Don't you have to give us the weights and the percentages? No. All I'm required to give you is the relative importance, to state the evaluation criteria and the relative importance of that criteria. And that's what I'm doing. Well, doesn't this have to be objective? How can I tell if you're doing this, evaluating me objectively, if you don't list points and weights? Well, number one, this is not an objective evaluation. Evaluation is occurring is a subjective process. No one is saying it is an objective process. We have an evaluation committee to evaluate. And the mere fact that you assign points does not make it objective, because you subjectively are assigning points. So you cannot make something objective that came about in a subjective method or manner. Have I confused you? If I have, stick around to the sealed proposal class and I will confuse you even more. Let's see. I've already mentioned the third one, criteria may only be used to evaluate information the offeror has or should have submitted. So you can't use it for anything you have not required them to submit. Criteria should address all the information that the offeror has been told it must submit. In other words, you can't What you should not do is ask a vendor to give you information. And when you get right down to it and you look at the evaluation criteria that you identified and you say, gee, there's nothing that allows me to consider what they gave me. So you have to use the criteria you did identify, and you can't use anything you didn't identify. So you want to make sure that everything you've told them to give you, as far as information, you have a criteria that allows you to evaluate it. Usually this is not difficult, but you just want to make sure that these things are current. And you should use, in almost all instances, economic benefit as one of the evaluation criteria, almost inevitably the last one. And again, you will not say that, for instance, I've seen vendors, agencies try to say that criteria 1 is substantially more important than criteria 2. Criterion 2 is of slightly more importance than criterion 3. Criterion 4 and 5 are of equal importance. That's going way too complicated, because we can't make it that finite. Just descending order. That's all you say. Yes?
I've noticed past performance is not on there.
We just said what the evaluation criteria is. The evaluation criterion can include experience.
Past performance on state jobs, things like that.
Didn't we go over the clause for prior state experience? So that was on, what, second day, something like that?
That would have been under here where you say technical proposal evaluation criteria.
I didn't seek to identify. The only reason I said economic benefit is because that is specifically identified as a criteria that you should use. The only time you should not use it is a situation that I have never had happen, and that is when you have a federal prohibition against the use of it. And I know that has happened at least once or so with Department of Human Resources. It might have happened for something here like medical assistance if you're getting substantial federal funding. In situations where the feds have to review your solicitations before you issue them, generally they will prohibit you to use economic benefit as an evaluation factor, and I think there's something else they don't use, allow you to use. I don't remember. But other than those situations, you should use it if you're doing a sealed proposal procurement. Let's see. State that the award was made to the responsible offerer whose proposal was most advantageous to the state, considering price and the technical proposal evaluation criteria set forth in the request for proposals. So you will state, we're going to do a best value award, most advantageous offer. And then the other thing you are required to say is the relative importance of technical and financial components. And you have three choices. And you can start from technical or from price, either way, but you got three choices. It's going to be technical factors are worth more than price, technical factors and price are equal weight, or price is worth more than technical factors. Up until, when was it? Was it May of this year or May of last year? Pardon me? Enrollment broker contract.
That was the reason for the protest. That we had said that technical outweighed price, and after that it got changed.
I don't think that's the reason.
Okay,
Yeah,
I
it
don't.
was.
Is
That
that?
was the reason.
Well, I don't know. I don't think that was the reason.
That was the reason.
There were a number of reasons.
Very good.
$5 million might have been one of them. $20 million was a reason, $9 million was a reason. There were a number of reasons. And there seemed to be many instances where state agencies seemingly ignored price. That they seemed to take the fact that they could have, the technical factor had more weight than price and almost mean carte blanche, well, we're going to award to number one technical. Almost irrespective of how much technical superiority there was between number one, number two, number three, etc., and how much price difference there was. To the point that at times it seemed ridiculous when a vendor who was number two ranked technically, not terribly, much different than number one, but there's like a $12 million difference in price. You take number two for $12 million less. So all you have to say is which of those factors have the relative importance, and what we are saying now as the default position for services that come through DBM is technical and financial factors will have equal weight. So what that supposedly means is that you don't just automatically, as a knee-jerk reaction, go with number one technical, that you have more analysis as to who is giving the best value. And if you want to award to number one at a higher price, you need to have a little more justification of why you think that's the most advantageous offer to the state. The thing that I've explained to various people is that in most instances, or in many instances, the relative importance should make no difference in who you recommend for award. A vendor that is clearly technically superior, that is not very much more expensive, should win regardless of how you have weighted technical and financial. Conversely, vendors that are virtually equal technically, price will have a magnified importance anyway, because there might be more difference in the price disparity than there is in the technical disparity. And if a vendor is just way lower in price, but they are technically qualified and you believe they can do the job for that way lower price, you take them, even if technical has more weight. And seemingly people didn't pay enough attention to those factors. They just said, technical's worth more, we go with number one technical. So we made them think. Equal weight, and you have to have justification that we agree with, if it's a service coming through DBM, to allow technical to have more weight than financial, and we don't give much approval for that, but we will let you, without blinking an eye, have more weight to financial than technical. If you say you want more weight to financial, no problem. We'll sign off. Yes?
More weight is technical. It would be harder to have a protest against that, wouldn't it? Because it'd be hard to prove why.
You're talking about defensibility of a protest. You almost inevitably will win any protest concerning an evaluation. The state wins at least 85% of the time, if not 90% of the time. So basically, when the state loses, what that means is somebody really messed up. The Board of Contract Appeals has said in many, many occasions, they will not substitute their judgment for the judgment of an evaluation committee. All they will look for, and what a vendor has to prove, and the burden of the proof is on a protester, is that the decision by the state was arbitrary and capricious. And so that's why you will see these words probably 20 times in a protest. You were arbitrary and capricious in doing this. You were arbitrary and capricious in selecting this vendor. You were arbitrary and capricious in overlooking our price differential over and over. But when it gets down to them having to prove it, it almost never happens, because typically you are not arbitrary and capricious. Typically you can come up with the reasons why you made the recommendation you did. And proving beyond a reasonable doubt that you were arbitrary and capricious, we win. And we don't have to prove that we were, they have to prove we weren't. So the actuality is, it may take a lot of time and effort to get to winning, but it's almost a foregone conclusion we will. And I only know of a couple instances where the state has not won, and one of them occurred 3 or 4 years ago when, through the testimony to Board of Contract Appeals, and particularly the discovery of documents, that it was discovered there were emails that were going from the chairperson of the evaluation committee to one of the vendors, that the interpretation of the Board of Contract Appeals was the chairperson of the evaluation committee was saying to the vendor, it's in the bag, don't worry about it, you got it. And even though the procurement officer advised the evaluation committee to have no independent communication with any of the offers, this person didn't listen and had email communications back and forth, and the state lost because the Board of Contract Appeals determined there was bias on the part of the evaluation committee against the one vendor who did the protest, and that's one of the rare instances where the state lost. So you don't have communications and you don't put emails, because if you attended the Board of Public Works seminar July 31st of a year and a half ago, the members of the Board of Contract Appeals, 2 of them, made a presentation. And they had the 10 list of things that you should remember, and one of their points was, emails are forever. Because even if you delete an email, it can be retrieved from the system. And when they petition the state to provide documents, they can go and they can get that email. So at some point, it can be discovered. So you just remember, emails are forever. All right, let's see. What else do we have to say? So, you want to hear about regional and functional awards? Oh, definitely, yes. The outpour is deafening. Isn't this wonderful stuff? The problem is that it's information that hopefully you agree that you kind of need to know, but no one's going to tell you this is the most exciting stuff. And we don't have you get up and do jumping jacks or anything like that. We just try to, every now and then, get a laugh or something. Regional and functional awards are discussed under the multiple awards section under consolidated solicitations, and shortly we're going to get to multiple awards. Are used when it is determined that having a single contractor provide all the needed goods or services of a particular type is not in the state's best interest. So this is where, in the planning stage, you're making your decisions. You're writing specifications, but one of the things you have to decide is, do you intend to make a single award, or do you intend to make awards broken, either multiple awards, or we're going to break down awards in some fashion? And the fashion you do it is geographic, regional means by geography, or functional, which means by subject matter. So rather than have one vendor do everything, we're going to do a breakdown. And we're going to tell you when that seemingly makes sense versus when it doesn't. Now, your dilemma is figuring out when you have the circumstances we're going to describe versus when you don't. A single contractor might not be in the state's best interest because, number one, you have an issue of capacity. If you have a single vendor, can that single vendor provide everything that's needed, everywhere it's needed, to the same level of quality, in particular to the same level of timeliness? And if you're talking about something that has to be provided geographically, can someone who is headquartered in Howard County or Baltimore City or Baltimore County or Anne Arundel County timely get something that's needed in Garrett County, Allegheny County, Somerset County, etc.? Probably more Somerset than the other ones, but you have that geographic issue. Is it feasible for one single vendor to be able to do this? And beyond, is it feasible for one vendor to do it? Are you getting down to only perhaps one or two might be able to do it? Because if you're getting down to where it's very restrictive as far as how many vendors can respond, they will know they're the only vendors that can respond. So they will know they're in the driver's seat, and they will know that they can price accordingly. So you may, because of a virtually monopolistic situation, simply do it regionally to try to convince a vendor that it might have competition, at least on a functional or regional basis. So let's see, lack of capability, geographic or topical or expertise perspective, a variation of the theme that none of us is as smart as all of us. You have more capability typically if you have more vendors. Also might be more expensive. Sometimes you will realize economies of scale, and sometimes it might be the opposite. And all again you have to do is decide which way it is, cheaper or more expensive. It may disfavor Maryland's small or MBE vendors, and I've heard this many a time. Well, with what you have required and with the minimum offer requirements that you have given, I can't even compete. I'm the small guy. I'm trying to get in there. I'm trying to get bigger. I'm a Maryland firm, and all you want to do is write your specifications so that only the big national firms can compete. So where am I in this equation? So a functional or regional award might allow small and minority vendors a better than even opportunity, well, certainly an opportunity to compete and maybe win. So if you don't have it so that they can compete, they're never going to get any bigger if they can't win anything. A single contractor might lack the capacity to satisfy all needs at the time the needs arise. This is particularly pertinent when you don't know when you're going to need something. And an example is if you have a nursing contract for a facility, that you have a vendor for on-call, to provide nurses on call when your staff nurses are sick or something like that. And so if someone calls in at 8 o'clock in the morning and says, I'm sick, I won't be coming in, they're supposed to work on the 3 p.m. shift to 11 p.m. shift, do you have a vendor that you can call right then and there with the expectation that they will be able to provide a nurse in 7 hours notice to come in and provide someone? Now, if you have a single vendor and you have this type of situation where you want them to provide someone as needed when you have no idea when you're going to need them or where you're going to need them, is a single vendor going to have the capacity to provide what you need? And that may be the case if they are huge. But a lot of things, such as nursing services, they're not huge. And if you call them up in 7 hours notice, there's a good likelihood they can't provide anybody to you. So multiple awards might allow you to meet your need, whereas one vendor may not be able to satisfy that. So that's a situation where that may make sense. The state might sacrifice timeliness or quality for one contractor to attempt to meet the unknown level of timing or needs. Geographically, there may be areas of the state that do not receive the same level, i.e. timeliness of service, as other areas because they are too distant from the contractor's performance location, and it is uneconomical for the vendor to open new offices. If they only have very sporadic business in Allegheny or Garrett or Somerset, they're not going to open a new office. And if they have to serve it out of an office in Baltimore or Prince George's or Montgomery, they're not going to be real anxious to, at every phone call, drive out to Allegheny or Garrett or Somerset, etc. So those distant locations, if you are with one vendor, may always get the short end of the stick. There may always be performance issues. Maybe they do a fine job in the central area, but maybe there's always performance areas in the outlying areas. And so that's the situation where does it make more sense to do regional awards so that you can award someone who is located in Salisbury or Hagerstown or Cumberland and have them just serve the area that they already serve, but more than just one that's centrally located. So that's what that says. A single contractor may lack the capacity to satisfy all needs functionally. That is, they don't have the expertise. They don't have the technical know-how to do everything that you might want. They may have certain areas of strength. They may be able to do everything to some degree, but they may not be the greatest expert in all areas. So sometimes you're sacrificing the quality or the best vendor by picking one vendor over the ability to select multiple vendors that each might have a particular niche area and be supremely competent in that narrow area. So functional awards allow you to potentially award to the vendor that has the best capability in a particular subject matter. Let's see. They may be small vendors with the highest level of expertise. The state will not be able to benefit from this expertise if a single vendor has to be selected that has a broader array of expertise, but that expertise is not as deep as the niche vendor. It would be the analogy to a jack of all trades but a master of none. And if you're making one award, that one award inevitably is going to be to the vendor that has some capability in every respect, even though they may not be the best in any single area. But if other vendors only have really good capability in one area but can't do 10 other, you're going to pick the one that can do everything to some degree, which means you're sacrificing getting the best vendor for each particular subject matter that you may require. So maybe a reason why you make functional awards. I don't know whether I have to do it 10 times for it to move or just what the secret is. So we talked about capability from a functional standpoint, then we're going to again address the issue of functionality from a time standpoint. A single contractor might lack the capability to satisfy all needs in a timely manner, will be less likely to have, and I'm going to emphasize this concept a little bit, idle resources. A single vendor may be less likely to have idle resources that can promptly be applied to the state's needs. A contractor might always be reacting at the maximum allowed response period or maybe exceeding it if it's juggling too many customers to respond promptly, or it may handle its more lucrative customers first. If you have one vendor, that vendor is going to staff for its peak demand, and it's not necessarily its peak demand, it's typical demand. And if there is demand beyond that, usually it's not going to staff up just to handle the peak circumstances. So what's going to happen is we're going to suffer whenever they have a lot of demand, and state contracts frequently are not the most lucrative contracts for vendors. I mean, they always complain they make no money from us. So if they can make more money with other customers than they can with the state, we're going to come second to the other customers. That's if you have one vendor that has to do everything. A single vendor contractor might be more expensive for these type of reasons. It may require a significant expansion of the contractor's resources to attempt to meet all the needs. It can't do it, so it has to hire more people or open new offices, and if it doesn't have sufficient business, you're going to be paying the freight to do that. And so it may actually cost money to try to get just a single vendor, because we're the one that's going to pay for that excess capacity. And it may be less expensive to seek to use the excess capacity of multiple vendors than to pay for but only partially use the expended capacity of a single contractor. If you have multiple vendors, it's likely each of them are going to have some excess capacity. That means at times they're going to be sitting there with people not going out in service calls, something of that nature. So at any point in time, if you have more than one vendor, you are more likely to be able to get to a vendor that at that point in time has the ability to respond immediately. So these are the type of situations that may make sense to make multiple awards by region, these are not necessarily multiple awards, but these are either regional or functional type of awards. So it's a determination you need to see in your planning stage whether this type of thing makes sense. Let's see, I think I said that. Oh, the more expensive scenario will not exist if there are multiple vendors that each have sufficient capacity to meet the state's needs at any projected level or frequency. And these are two examples. Federal Express or UPS can handle every package need in the state. I mean, they are designed to handle thousands and millions of packages. So we could award to, if we had a single vendor to handle our package delivery services, either one of those, and maybe others of them, could handle the capacity. So that's an example of where a single award would make probably economic sense, capacity sense, and everything of that nature. But that's the type of scenario where that might be limited to something of that nature rather than functional or geographic. And there are certain vendors that can handle all the photocopy needs. So sometimes it makes sense, sometimes it doesn't. Regional and functional awards foster opportunities for smaller vendors. As smaller regional or topical vendors already exist, they can readily accommodate the expected usage demand within their geographic area or field of expertise. They are staffed, they are the size to handle the things that they already are in business to handle, so they should be able to do it for the future if we have these regional or functional awards. Excuse me, it is beneficial to capitalize on this, and also is may provide the business to allow these homegrown Maryland firms to grow and expand. Since small regional vendors are more likely to be Maryland resident vendors, including Maryland certified small businesses and/or MBEs, regional functional awards can be an indirect means to help small and MBE vendors. So if you want to try to get your numbers up for MBE, if you want to try and get your numbers up for small businesses, this might be an indirect way to help you get there. Without a goal, without any other artificial means, it may still allow you to get there. Another consideration. So it could produce a win-win scenario where the state can win because of more competition, which produces lower prices, better quality, better timeliness, and vendors can win through more opportunity for resident, small, and MBE businesses. Yay, yay, clap hands, good thing. And believe me, I have been at Board of Contract Appeals meetings where agencies will come in with awards for a single vendor, let's say to handle things on a statewide basis, and many times they only have one vendor responding. And the typical response from the board members is, why did you only have one award? This doesn't seem to make any sense to me. Why didn't you break this down so you could have awards in the different areas of the state? I know you'd have gotten vendors that would have bid if you'd have done that in different fashion. And sometimes I've even had situations where some of these small vendors have complained to members of the Board of Public Works that they would have liked to have responded, but based upon the fact that it had to be everything, they weren't big enough to do everything. And here the state is, by their specifications, keeping them out of the running, this small Maryland-based vendor. And so the board members will at that point be very difficult with the agency personnel standing before them trying to defend why they made a single award. So it's something for you to consider. Any questions on regional or functional awards? I know you're just brimming over with questions and enthusiasm, and you're saying, how many more of these do we have to put up with? Another half hour. 31 minutes. Maybe we can get out of here early. No such luck. I don't work that way. Basis for award, multiple awards, and these are multiple awards from the DBM perspective, because if you look in COMAR, there isn't a whole lot that's identified in COMAR about multiple awards. So you're having the advice according to DBM. Multiple awards, what they are, when and how to use them. Definition, so here's what a multiple award is, and it's not my definition. This is the definition of 2101-0201B58. Multiple award means the award of contracts to more than one vendor for the, and I want to emphasize, the same goods or labor, for the same good or labor. If you think about what I just went through with regional awards or topical or functional awards, we're not saying that if you have 4 regions, you're going to have multiple awards. You're going to have 4 vendors potentially, each one for a given area, but nothing says there's going to be more than one vendor for that same area. You can, but regional or functional in and of themselves do not constitute multiple. Here we're going with where it is multiple, and that is when they're doing the same, the vendors are to do the same good or labor, the same activity. So that's multiple. Let's see, multiple awards, what they are not. So we define it and then we tell you what it isn't. And it is not awards from the same solicitation to different contractors to perform different activities, what I just described. Perform the same activity in different regions, perform different topic or functional areas. So fact that you have 4 regional awards does not mean you have multiple awards, unless you have multiple awards within each of the regions. Then you have both. Consolidated solicitation. This is when multiple contracts can result from a single solicitation. Typically, if you have awards by region or by functional area, you're going to do one solicitation that covers all of that. You're not going to do one solicitation for Western Maryland, one solicitation for Eastern Shore, one solicitation for the Metro DC area, one solicitation for the Baltimore Metro area, one solicitation for Northeast Maryland. You're going to do one solicitation that you will make awards by Western region, Eastern Shore region, etc. Because 90 or 95% or even 98% of the solicitation is going to be identical if you would do multiple solicitations. So it doesn't make any sense to issue 5. You just do 1 and say, we will make awards by region, by functional area, etc. So that is a consolidated solicitation. And generally, only one contractor will perform a given activity, either by geographic area or functional area. But again, you can also have multiple awards within functional or geographic awards. Multiple solicitations, as I just said that, with virtually all aspects, and it's more convenient to issue a single solicitation. I've said that. Generally, if you have a consolidated solicitation, vendors are allowed at their election to respond to one, some, or all of what you're going to make awards on. They can respond to all regional areas, all functional areas, or just one. So they pick and choose themselves what they want to respond to. And the fact you allow that to happen means you're encouraging more competition. The vendors can focus on just what they want to serve and respond just to that area. So hopefully you'll have a mixture of some vendors that are going only after 1 or 2 of the breakdown areas or functions, and some that might pursue all of them. And it's all competition. Let's see. Even if vendors are required to respond to all, sometimes you require them, you will still say you're going to make the awards individually. So even if you say you have to respond to all 5 areas, which may make sense or may not make sense, and obviously if it doesn't seem to make sense, you don't require that, but even if you require it, you still say at your discretion, you will award to the single vendor in each regional or functional area that you determine to be either most advantageous or to have the lowest price, depending on what your award mechanism is. So that's all from a consolidated solicitation. Consolidated contract results from a consolidated solicitation. Consolidated solicitation, consolidated contract. It results if individual awards were made for different geographic or topical functional areas and a single bidder wins more than one. So even though you've allowed the fact you're going to award by region or by functional area, you can pick one vendor to win all of them or some of them. And if you do, just as it made sense to have a consolidated solicitation, because 90, 95, 98% of the words would be identical in multiple solicitations, it makes sense to have a consolidated contract where all the terms and conditions, the mandatory clauses, etc., are identical, the identification of the vendor is identical, etc., and you just have the individual differences of, for functional area 1, they will do this, for functional area 2, they will do this. So you will just acknowledge their separate proposals, their separate prices, etc. But again, 90-some% is going to be the same, so you have a consolidated contract. And in your solicitation, you want to say that. In the event a single vendor wins more than one award, we will issue a consolidated contract to that vendor. Because you already have said that you're going to make contract awards by region, by functional area, so you want to reserve the right to not do it if a single vendor wins more than one. Let's see. Master contract. And you've probably heard this term before because it's used a lot by DoIT for their CATS contract. We at DBM have it for foreign language interpretation, for auditing services. We're going to have it for visual communication. That means we're doing a procurement for sign language interpretation. Let's see, master contract. We undoubtedly have a couple other master contracts. So master contract is common terminology for the contract that results from a multiple award solicitation involving secondary competition. Secondary competition is an important aspect. What that means is a vendor is going to win, if you will, the first stage. And only winning the first stage still doesn't give them any usage, doesn't give them any benefit. All it means is it means they're eligible to participate in the second stage. It's like going through a pre-qualification race or a preliminary playoff or something like that just to win the right to go into the final playoff or the final race, etc. So if you have this type of scenario, what you must have is all terms and conditions governing the secondary competition. So you're going to say, we're going to have master contractors, and the master contractors will be able to compete for an award on a task order basis, and here's the scenario that will apply to the secondary competition. And you also say the secondary competition will provide additional specific details of what is provided, and the one thing you must say is the specific details, i.e. the task order, cannot conflict with the master contract. The master contract is the superior document. So the secondary competition will say who, what, when, well, not who, what, when, etc., but it cannot replace or be at variance with anything in the master contract. That is the prevailing document. And that is why we do not call the secondary competition a procurement. From our standpoint, a task order request for proposal is not a procurement. The procurement is done to get the master contractors, because you are required to get prices, at least prices that cannot be exceeded at the master contract award level. The vendors are required to sign contracts with the state that include all the mandatory clauses, etc., so that all the preliminaries out of the way, and now all they need to do when there's a task order is respond specifically to the task order with how they're going to do it, when they're going to do it, and what their price is. And it's not a procurement. So they can't, from our standpoint, and no one has tested us yet, they can't protest a secondary competition. It doesn't have to go to the Board of Public Works for approval. So it's faster, easier, without a lot of complication, but it still allows vendors to compete for specific details of responding to the needs of a state agency without the same time, the same complexity, the same involvement as a regular procurement, and without the possibility of protests. Isn't that nice? That's our story, and we're sticking to it. Nothing has ever gone to the Board of Contract Appeals to test our theory that this is not a procurement. But so far, most people seem to have signed off on it. Multiple proposals pertains to the number of responses a single offeror can provide under a competitive sealed proposal procurement. So I'm going through the aspect, if you remember, is talking about multiple awards, and now I'm talking about all the things that aren't multiple awards. They're multiple this, multiple that, but they're not multiple awards. So we're not there yet. We're doing these things to eliminate confusion or possible confusion. The number of responses an offeror can provide under competitive sealed procurement has nothing to do with how many awards can result from a procurement. Multiple award is not the same as multiple proposals, and we talk about multiple proposals on 816. So just remember, multiple proposals is not multiple awards. I mean, it's something you can say rapidly 3 times and it's worthless. That makes no sense because I'm trying to be funny. Multiple awards is not the norm. That is not what we typically award as a result of state procurements. Normally, we award a single award, but we're just letting you know that you don't have to, that this is an available methodology, and you have to decide whether in any particular circumstance that you're procuring, making multiple awards might be better off for you and for the state as a whole. So you have to decide, do you want one or more than one? Let's see. Examples of valid multiple award: temporary help, on-call nurses, in-home aides, auditors. Many situations it may make sense to go with this multiple awards. Multiple awards and procurement methods. Most procurements, most awards are done by sealed bidding and sealed proposals, so it's not surprising that most multiple awards come about through these two methods, including multi-step. But theoretically, I don't know if I've ever seen these instances, but theoretically, you can make multiple awards in an emergency situation. You can make awards under expedited, which none of you, including me, can't do because only Aviation Administration and Port Administration can use this method. Theoretically, can be under negotiated award after unsuccessful competitive sealed bidding. Theoretically, can be done under intergovernmental cooperative purchasing, and theoretically can be done under small procurement methodology. I've never seen any of these, but just doesn't mean that you couldn't necessarily do it under these. I've seen it all the time under sealed bidding and sealed proposals. Small procurement, obviously, you cannot artificially subdivide a need by making multiple awards for each of those multiple awards to fall under the small procurement threshold of $25,000. Now, you cannot use it for sole source, and you think about this a moment. How can you have more than one vendor that can provide a sole source? If you have more than one vendor, you don't have a sole source, you should have a competition. And it's not going to be applicable for negotiated award of human, social, or educational services because by very definition, for this to apply, you have to have an absence of effective competition. And what that means is there is more supply than demand. So you're not going to be making multiple awards when you need every vendor you can get. And that's what that means. That's procurement that can be done by DHMH. You cannot be done by environment. And it's done only for third-party clients. And so DHMH, you have third-party clients. You do use this method, but most of the activities under this anymore are now exempt from procurement. So you would not use it for that. So we're just talking about where multiple might apply and where it might not apply. All right, continuing with 21060310. State agencies shall order all of their actual normal requirements for the specified supplies or services from contracts awarded to contracts. So if you do a multiple award contract, use the contractors that you get through this procurement to provide the activities that you do the procurement for. Okay, but what that doesn't mean is you are required to use them in any and all situations. If you have a situation of extraordinary demand, you don't have to stay with these vendors. You can do another procurement, you can do theoretically even an emergency to get peak demand if you determine that you cannot get other than normal requirements from a multiple award contract that you have. A multiple award contract. A multiple award may be in the state's best interest when an award to two or more bidders or offers for similar products is needed for adequate delivery, service, availability, or product compatibility. This is continuing in the definition as to when you can use multiple awards. Delivery, service, availability, compatibility. And I emphasize this because I think this is of crucial importance. And one of the reasons why I will advocate certain things and not advocate other things because of this statement right here. In making a multiple award, and let me highlight. Care shall be exercised to protect and promote the principles of competitive solicitation. What does that mean? Just reading those words, what does that mean to anybody? Protect and
Share the wealth.
share the wealth? Is that what it means to anybody else? Protect and promote the principles of competitive solicitation. Yes?
You don't want to segment it so there's really only one offer per, you don't want to set up a sole source type of situation.
Don't want to set up a sole source. Okay.
Just the reverse, you don't want it so loose that anyone can just pop in there just for the sake of having more than one vendor.
Okay. All right. Anybody else? I'm looking for something that I'm not getting so far. All right, let me tell you what it means to me. That vendors that are better, vendors that are cheaper, are used more and get more benefit than vendors that are not as good or that cost more. Competition, the reason why we do competition is to get vendors that perhaps have better capability to provide what we need and hopefully can do so at a better price. And one of the axioms of business world is that frequently they will sacrifice price for volume. That lots of times if they lower their price on something, they do so because they expect more people to buy it, so that the end result is that despite getting paid less for it, there is so much increase in demand that they still make more overall money by lowering a price. So that is a specific strategy in many situations. Of course, there's vendors out there, there's stores out there that operate on low price basis because they're looking for volume. And if you use that principle, what we want to be able to do is reward vendors that give us better results, better capability, or lower prices over vendors that don't. So, although this is not defined anywhere, to me, what I've just said is what that means. Does it sound reasonable? I hope you agree that it is reasonable.
I would have added to it in the U.S. market, because we could
Okay.
ship every one of our jobs overseas and not have any market at all.
Probably everything can go to China, yeah, since most of it seems to already done that.
Yep.
And here is a prohibition that is still in 21060310. Multiple awards may not be made when a single award will meet the state's need without sacrifice of economy or service. So you can't make multiple awards if one award will do it. But all you have to do is determine one award won't do it, and then you can make multiple awards. Key factors for valid multiple awards. Limitation of the availability of a good or service. In absolute terms, if there is scarcity of the needed good or service, no single vendor has the capability to provide what is needed. If it's a seller's market, we need every seller we can get. So you want to make multiple awards so you can get as much as possible from each of them, because other than that, if you go to just one vendor, we're going to have less than what we need. Maybe even with multiple, we still have less than what we need, but at least we'll have more than if we just get it from a single vendor. So the absolute doesn't happen very much, but the second one does happen, the practical terms. So if there's a limitation of the availability of a good or service in practical terms, and that has to do with the variability, unpredictability of need. Both the level of need, how much is needed, and when the need occurs. These are the key factors. Again, if you don't know how many nurses you're going to need next week, tomorrow, today, a vendor cannot staff up to provide that level of need if it doesn't know what you're going to need, both how many or when. So maybe even if you tell a vendor, we're going to need 20 people in the next year, the vendor still doesn't know whether you're going to need 20 people at one time or one people spread over 20 different periods of time. And if you have one person spread over, 20 people spread over, let's say, a 2-week period each, a vendor can probably have the same person each time and be able to handle it very readily. But if you come and ask them for 20 people on the same day, it probably can't fulfill the need because it isn't staffed up to handle a need of that nature. So the unpredictability, the variability of what and when is the key factor to you perhaps wanting to do multiple awards. And if you only have one vendor, it's either not going to be able to provide what you need, or it's going to have to staff up to provide your peak demand. And most of the time you're not going to have peak demand, so you're going to pay for it staffing up to provide peak demand even when it doesn't. You don't require the peak demand, so you're paying for the vendor's excess capacity. Let's see, if a single vendor, contractor, is required to provide whatever level of need arises when the need arises, the contractor must have available resources, staff capacity, etc., to assign to the need at any time. Available capacity costs money. Believe me, vendors know that, and vendors are either going to avoid a situation where they have to provide anything whenever needed, when they don't know when it's needed, or else, or they're just going to not respond, or they're going to charge through the nose for the capacity. Available capacity costs money. The state would need to pay for the contractor to maintain this capacity. We pay for the capacity regardless of whether it's used. We started out in the first day and talked about worst case scenario, that we were paying for worst case scenario, whether it happened or didn't happen, because a prudent vendor is going to price as if it's going to happen. So from this standpoint, the worst case scenario from a vendor is, how many people are the state going to come to me and ask for me at one time? And that's the worst case scenario. I have to staff up for that. I'm going to charge for that. And what we said is, excuse me, what it makes sense for the state to share in the risk, you share the risk by having multiple awards. So a vendor does not have to staff as if it has to supply everything you may need whenever you may need it. Because doing that means most of the time we would be paying for nothing. If we don't need it most of the time, but the vendor has it sitting there ready to give to us if and when we need it, we have to pay for it. So we're paying for something we're not getting. It is not efficient to pay for idle capacity. It is not recommended state agencies enter into such contracts. This would only make sense for critical activities. When you pay to have people in a fire station, because when a fire happens, it doesn't matter if it only happens once a month. Excuse me, when it happens, you want someone there to respond immediately. That's the kind of thing you'll pay for excess capacity, to have it there when you actually need it. We don't usually have that scenario. Or if there would be little idle time, so that most of the time we're not into paying for excess capacity. So, and what we're talking about there is a minimum guarantee, which we will talk about later, not today. So this would only make sense if paying for all the vendor's time is less expensive than if payment was only made for the actual time used. And we get into that when we talk about minimum guarantees, assuming we get to that on Friday. But it's in the slides. You will get the final batch of slides on Friday. There's still 231 to come. Let's see, recipe for no responses. Vendors must pay their employees in bills. Constant availability equals constant expense. Keep that in mind. From a vendor standpoint, if they have to have the capability to respond to you whenever needed, they're going to be incurring expenses to do that. So constant availability equals constant expense, which means all the burden of risk is on the vendor, the burden of risk of being adequately compensated so it can stay in business. And there was a solicitation one time from an agency for courier services where they required the vendor to have a 24-hour-a-day, 7-day-a-week call center to accept calls from the state for the vendor to respond to delivery on 2 hours notice anywhere in the state. And I read that and I said, this is the most ridiculous thing I've ever seen. because what vendor is going to have a call center staffed 24 hours a day, 7 days a week for a call that's going to come in when 98% of the state only works from like 9 to 5. And so the notion that we're going to call a vendor at 2 o'clock on a Saturday morning to come and pick up some package to deliver, let's say, in Allegheny County. And first of all, you can't get everywhere in the state in 2 hours. So for this particular solicitation, I said, that's a practical impossibility. If they're going from one end of the state to the other, they can't get there in 2 hours. So putting it in the specifications that that's a requirement doesn't make sense. And having a vendor charge for this, and the only way they could get paid for this call center, this 24-hour a day, 7-day a week call center, was if we actually had a package delivery, then they could charge their unit price bid rate, which in that case was something like $20 a package. So for something that probably was never going to happen, they might make $20 for something that would cost them tens of thousands of dollars a year to comply with. It just was totally bizarre, made no sense. But there was a procurement that happened, and fortunately, it never got awarded because we wouldn't let it be awarded. Let's see, constant availability. No prudent vendor would respond to a solicitation that requires constant availability but did not pay for that availability. Probable means 3 minutes. You're waiting 3 minutes. Let's go 3 minutes. Payment for rare usage situations needs to be very high to pay for uncompensated time, i.e. in those situations I just described, if all you get paid for was a single package delivery, that package delivery is going to cost $1,000 a trip in order to perhaps compensate for the vendor. Of course, if it costs $1,000 a trip, we're never going to use it. So the vendor's in the catch-22 situation if they would respond to something of that nature. It just didn't make sense. Or cost and availability could be provided in name only, and this is the thing that probably is going to happen. Yes, the vendor says, I can give you however many people you need, wherever you need them, whenever you need them, which is fine as long as you never need them, or never need more than one at a time. But as soon as you find that you have a need beyond the norm and you call them, the answer you're probably going to get is, I don't have anybody to do that. You know, it's not reasonable for you to just call me up. You've already given me 1 order, 2 orders, everyone's out, I just can't handle it. And so it was a procurement that seemingly would get you something that when you actually went to use it, it was a mirage. So let's see, the vendor likely would not willing or have the ability to provide what was needed within the time frame needed when there was an occasion of need. So that's the other thing that's going to happen if you don't price for the peak situation. Let's see. Well, all right, we're at slide what? 86, which translates into something else. So on Friday, we will start on this slide, picking up with multiple awards.